Okay, let's dive right in. If you're prepping for your Australian contract law exam, you know the feeling. It's like staring up at a giant mountain of cases, and you feel like you have to climb the whole thing. But what if I told you there's a smarter way to the top? This is your guide to absolutely acing that exam, not by memorizing more, but by revising way, way better. Does this look a little too familiar? Just an endless list of case names. From Australia, the UK, it's a lot. And it is completely overwhelming. You've got everything from the classics, like Carlo versus Carbolic Smokeball Co., all the way to modern ones, like Pasioco versus ANZ. The sheer volume can make you feel like you're lost in the wilderness before you've even started your journey. But here is the secret, the thing you really need to get. Examiners aren't looking for a walking, talking encyclopedia. Real success on this exam isn't about brute force. It's not about cramming every single case into your brain. It's all about having a powerful, targeted strategy. It's about knowing exactly where to focus your energy to get the biggest bang for your study buck.
So let's lay out that strategy, shall we? Consider this your roadmap, a clear path right through all the complexity.
Here it is, our three-step plan. First, we're going to make sure we've got a solid grip on the core structure of contract law. Second, and listen up, because this is the real game changer, we are going to zero in on where Australian law decided to go its own way, away from its UK roots. And third, we're going to master the IRAC method. That's the tool that turns what you know into high-scoring answers.
All right, let's get into the heart of our strategy. This is all about focusing on where Australian law is, well, different. You see, while a lot of our principles are inherited from the UK, the real marks, the top marks, are won by knowing exactly where our high court stepped in and said, you know what, we're going to do this our own way.
To be strategic, you've got to filter out the noise. Seriously, don't get bogged down in all the little details of UK law that just aren't relevant here. Instead, you need to pour your energy into three key areas where Australian contract law is truly unique. Estoppel, the idea of good faith, and of course, the Australian consumer law, or the ACL. Okay, so this is probably the single biggest split to understand. In the UK, estoppel has traditionally been just a shield. You can use it as a defense to stop someone from going back on their word. But here in Australia, whoa, it's a different story. It's both a shield and a sword. What does that mean? It means you can actually use estoppel to start a lawsuit, to enforce a promise, even if a formal contract doesn't exist. It's huge.
And the landmark case that made this all happen is Walton Stores v. Maha. This is a non-negotiable. You absolutely have to know this case inside and out. It's where the High Court basically said it would be completely unconscionable to let one party back out of a promise that the other party had already relied on and spent money on. This case is the very foundation of estoppel as a sword in Australia.
And it doesn't stop with estoppel. There are other divergence hotspots you need to know. For instance, Australian courts are way more open to implying a duty of good faith and fair dealing into contracts. Burger King v. Hungry Jack's is the go-to example there. And when it comes to false statements, forget the old common law stuff. Your focus has to be Section 18 of the ACL, which is our modern, powerful tool against misleading or deceptive conduct. Okay, so you've focused your revision, you know the key areas. Now, how do you actually use that knowledge in the exam? You need a structure. And in law school, that structure is IRAC. And trust me, this isn't just some boring format. It's a whole way of thinking that examiners are actively looking for. So for anyone who needs a quick refresher, IRAC is just an acronym. It stands for Issue, Rule, Application, and Conclusion. Think of it as a simple, logical framework that makes sure you hit every single part of a legal problem, step by step, so you don't leave any easy marks behind. Let's break it down really quick. First, you spot the specific legal issue in the problem. What's the question being asked? Then you state the legal rule that applies, and you cite your authority, your cases or statutes. Next, and this is the most critical part, you apply that rule to the messy facts of the problem. Finally, you wrap it all up with a clear conclusion. Now, let's talk about where students so often lose marks. The biggest pitfall, by far, is in that application stage. So many people will state the rule, then just repeat the facts, but they fail to actually connect the two. What you need to do is show how and why the rule works on those facts. Another classic mistake, forgetting to cite authority. Always, always back up your rule with a key high court case.
All right, let's bring it all home. Let's pull everything we've talked about into one simple, actionable blueprint you can take right into your exam.
Here is your game plan. It's this simple. First, stop trying to memorize everything and start being strategic. Second, focus your precious time on those uniquely Australian areas. We're talking estoppel, good faith, and the ACL. Third, make IRAC your automatic response for every single problem question. And finally, make your answers strong by anchoring them with those landmark High Court cases like Walton Stores. You know, the source material really just says it perfectly. Mastering these elements is essential for LLB assessments. Strong foundational knowledge enables clear, structured, and persuasive exam responses. And that's exactly what the strategy is all about. It's not about knowing everything. It's about building a strong, focused foundation that lets you be persuasive.
So there you have it. That's the path through the contract law mountain. You've got the map, you've got the method. The only question left is, which key Australian case are you going to master first?